I'm really concerned about the lack of critical thought. The way people in general, society as a whole, tends to latch on to a popular view. For example, Oscar Pistorius is guilty, Julius Malema should be stopped from sprouting hate speech. That there's very little querying of the legal implications of some of these judgments. And the legal implications can be very disturbing. To put it very simply, the Oscar Pistorius judgment, which reversed Judge Matsipa's judgment in the High Court, says effectively that they know that dolus eventualis, which means culpable behavior about the outcome of conduct, in other words, you know that the outcome might be killing and you go on with it. Firstly, the court equated that with murder. Now, the prosecuting authorities here and elsewhere have always wanted that. They want to get easy convictions. They don't want to have to prove intent. So they leapt on this popular case with a lynch mob mentality, the baying for blood for Pistorius, as a way of getting a judgment through that can make their lives easier in future and get murder convictions when there was in fact not murder. Dolus eventualis, being recklessness about the outcome, is not the same as intent. Putting a gun to someone's head and pulling the bullet, or driving recklessly and killing someone you didn't want to kill, are not the same thing. And that effectively is what the Pistorius judgment says. It has nothing to do with whether Pistorius was or wasn't guilty, but my concern is that this is very bad jurisprudence, very bad and dangerous law. Then if you take, for example, the AfriForum case, that is the Julius Malema singing Kill the Boer songs, the court held there that hate speech is not objectively hate speech, but is contextually hate speech. And it's got nothing to do with the intention of the person, whether they intend hate or harm, but to do with the context or the sensitivities of people who hear it. There was no allegation that there was actual effective incitement. There was no allegation that it had anything whatsoever to do with Boers actually being killed on farms. All that it was ruling was that Malema should not be able to sing a song of ambiguous meaning, and that I think is very bad for freedom of speech in a free society. We should consider somebody guilty if they are effectively an accomplice to the crime. For example, coordinating the robbing of a bank or coordinating a gang rape or whatever it might be. Speaking the words must constitute being an accomplice. Again, we have a bad law that has arisen from a popular cause. And so it goes. And my intention is to say to people, try to separate, for example, in the Nkandla case, that here you have the court saying that a public official in the executive branch of government can find somebody guilty, impose fines, whether it's the president or anyone else. There's no right of appeal, there's no due process, there's no check, none of the checks and balances taken for granted in a court are followed. And then this is now somehow the equivalent of a conviction in law. No. The public protector should be able to do investigations and file reports, which the people to whom she files them have discretion as to what they do with them. They might be guilty of reckless administrative or unfair and unreasonable administrative action, but they are not the equivalent of a judgment. Those reports can go to the prosecuting authority, and the proper place is a prosecution in a court and a court order. Here we have the Department of Finance imposing a fine based on an official not subject to appeal, having an opinion about something wrong being done, and the fact that it was President Zuma and Nkandla and popular views of corruption is not the issue. It is bad law. This is not what we want the law to say in a free, decent and democratic society. The reason we don't want bad law is because the consequences can be very severe. Take, for example, the Pistorius dolus eventualis case. This is like saying somebody who knowingly drives a car that has not had its regular maintenance or has worn brakes. They know in advance that they could have an accident and kill somebody. Or they drink and drive, like the Jub case. They know in advance that they could kill somebody. If they do not want to kill somebody, but in fact end up doing so, This case now, the Pistorius case now, means they will be as guilty as they would be if they deliberately drove someone down and killed them. Take, for example, the public protector, Madonsela. At the moment, she happens to be particularly popular. But imagine the worst person in that position. Imagine a very bad political appointment, a corrupt person being put in that position, and giving them this awesome power to be able to rule people to be guilty and impose fines on them. You wouldn't want that. The political abuse that could follow, the personal abuse, the lack of due process, the lack of all the complicated checks and balances that go into ensuring that our judiciary is subject to appeal, has public hearings, has pleadings, has expert witnesses, has cross-examination, and all of that that gives us confidence in the courts would be absent. So to know why it's a bad law, you need to imagine a bad person being given this power. You need to imagine this being used against good people. And just as a bad law can be used by a good person against a bad person to popular acclaim, it can be the other way around. And we always need to have laws where the law itself is our protection, rather than relying on the virtue of the people who interpret and apply and administer the law.